Good morning, friends. Sat Sri Akal, Adab, Namaskar. Now, this will be a new series of my videos, and during the last 10-15 years, a lot of files, a lot of books were shared by respected bungalow owners, and this is one such book which came to me through a bungalow owner from Landour. Well, I was taking up her case in the Supreme Court when her father had died. This is Wolfsburn. And this book came to me at a very later stage. Well, this is in 2016 when this book came to me. It is a book called Landour Report of the Land Tenures 1904. This book was compiled by E.H. Ashworth, Square ICS officer on special duty to Dehradun. Provide an order number so and so. I would call it that in Landour, when it talks of the superintendent of Dehradun was asked by Governor General Order number 1903-3872 to investigate the tenures of Landour lands and of the Landour Bazaar, specially, and a report was submitted, number 991, dated 5th February 1904. This was presumed order that I will draw up a record of rights for Missouri. Now, if this was a record of rights under the Land Revenue Act, the notification should have been separate, because the Land Revenue Act of Awadh, or let's say Madhya Bharat, was already there, or Bengal if it was made applicable. This means that in 1902, 1903, the kind of an existence of making of a land record of rights similar to the one made in Ambala means there was a dispute. So there is no specific mention. These were some examples which were being set for cantonment. So Ambala was one, and in Rangoon there was a similar one, and now in Landour. So Captain Mr. E.S. Ashworth, who was actually compiling. Now, what did he actually compile? In 1845, there was an inquiry, and the Zamindar theory weighed down the scales. So, after inquiry, these are the vernacular records which he is talking of. Government, on full inquiry and consideration, came to the opposite conclusion, viz. That subordinate proprietary rights existed in Doon as elsewhere. Board Revenue Officers Letter number 1871 forwarding Daniel's settlement reports at page 144, the last settlement of 1886 from Mr. Paw's settlement reports of 1890. Now these are some settlements which took place in this area. He is referring them. Now we come to para 35. He says, under the native king, the proprietary rights in land was vested in the sovereign and inalienable. So what does Mr. Trail writes? The paramount property in the soil here rests with the sovereign. This right is not only theoretically acknowledged by the subject, but its practical existence is also deducible from the unrestricted power of alienation which the sovereign also possessed in the land. These tenures, occupants were very indefensible, and as there were derived from the royal grants, either traditionally or existing, so they might be abrogated at the will of the sovereign. Now see, here it is coming, those words of 1765, royal grants. The same para in the line says that Mr. Trail, when was making this report, held the property of others, those occupant proprietors, if they continued on the state, sank into tenant of the grantee, who moreover by the custom of the country was permitted to take 1/3 of the state into his own immediate cultivation. Now the Akbari system was 1/3 of the produce. Of the remaining state, let's say 1/3 goes 2/3 of the caste, the right of cultivation rested with the original occupant, who were now termed Khaikar. So the distinctions from Thatwan or proprietors. Similarly, the Thompson inquiry and the famous minutes which he mentioned of 24 December 1841 set forth a principle for the same settlement and adopted the Hall-Mackenzie system. Now, this is the system and the settlements mentioned in Imperial Gazette. Residents within the cantonment and Landour should be liable to municipal obligations. Now, why is he saying this? This is 1841. Here, once again in 1845, proprietary rights in the soil were of the native kings or the sovereign. Same thing happens. So these reports were being culminated in 1903. Wells' report of 17th October 1843 is a complete gist as per the follows, which I will speak. I am actually not going to read the whole book. I am substituting some part of the book. Dominant features of the settlement by this officer are in favor of the proprietors of these grants. Now just imagine. So the Raja of Tiri, Sudarshan Shah Bahadur and Mahant Swarup Das have agreed to the board's proposal, which I will explain in the case. I have not determined the cantonment property boundary pillars owing to the difficulties with military authorities. The absolute tenure of grant should be qualified by municipal bylaws as to spring roads, cutting of timber, and my operation is not final, awaited to the approval of the government. Now in 1903, he prepares this grant register, and the same grant register was tendered to me by this bungalow owner of Woolsburn, and it mentions the bungalow's sale deeds from 1842, but the preparation of the register was in 1903. So, well, again stands a stand that all lands belong to the grantee, and government only had the right to what? The three acquisition rights. If there is water, spring, timber to these lands, and that's all. So, what is now the ground rent which must be these bungalow owners or these residents or these grantees were paying? The condition of the grant from a specimen copy of Exhibit 105, it will be seen that the terms of grant do not mention explicitly any condition. Now in 1903, the 1836 GJO does not speak. Shows signs of this. He anticipated that the residents would be empowered by a law to enforce bylaws limiting of public encumbrances or easements, the absolute proprietary rights of the grantees. This was indeed the intention of the government. Dehradun was to be made a regulation district, with the exception of Mussoorie, which remain a non-regulation area. Now this is where in Imperial Gazetteer it says there were two kinds of areas, the regulation area and the non-regulation area. Here this report in 1903 speaks of that, and it speaks of the 1842 report. Now it clearly said the regulated areas and the norm was subjected to special laws made for the self-governance or government of the area. We can read a letter of some 2nd November 1840 Now comes the story that Landour was a part of Northwest Province government as per Exhibit 22. I may anticipate by saying that eventually an act was drafted, apparently exceptionally from Shimla and Mussoorie. This was Bengal Municipal Act 1842. I have only been able to get the manuscript of this exhibit. It does not give me the committee any explicit power to prescribe rules. Bylaws were passed by Mussoorie committee and sanctioned with some revisions as per exhibit so and so. These will be seen as bylaws of making public roads and springs and whatever. So we have to see what is happening. Now the most important here, we have to, the same document shows, if we show it to the court, which is exhibit 78, extract of grant had to be like this and has different columns. So this discrepancies as per the original specimen is to be signed by the special commissioner. And does he do it? He doesn't. So the second most important part, which I just said, that Landour was a part of non-regulation territory and under the northwest frontier, which is Punjab. Hereby meaning that the Indian Council Act 1861 was applicable under section 42 of the Governor General Orders. Now, where is it notified? One has to read the whole book then, and there are small nitbits. If I speak on the YouTube, it will becomes very difficult for people to understand. Now, the difference, if we go by, affected the amount of the revenue, the rate which had to be collected, revisions of assessments had to be done. So all these orders were to be implicated, because the Britishers were only interested in revenue from the land. So the oldest Vazabulars of Mussoorie was available in 1842. I have so far been unable to obtain a copy of the grants conditions of 1838. Now 1838 is the GGO which is applicable in Bombay Presidency and the 1840. But I have come across a paper in a miscellaneous file of 1842, extract of the letter from the Revenue Survey of Superintendent Dehradun speaks in 1830. On the occasion of submitting a plan of the grant called Arcadia as a specimen by the way the lands were returned, the extract, although unsigned, appears to me to be in the handwriting of Captain Brown, who made the survey. Both the revenue settlements and wealth settlement reports follows in para 4 and 5. I now proceed to the notice the points mentioned in the corresponding regarding the grants on which it is expected I should afford information. The grantors should be called upon to make the required roads through the grants, and government reserves the right to the stream of water in case it should be found desirable to establish a system for its distribution. Likewise, a right to make canals and roads through the lands as well as the encompassing grounds. This shows the intentions was given the grant of 1838. In the grant again of 1845, the rights of the government, again all minerals, right to distribution of water, irrigation. This again rose to a settlement report of 1852. Similarly, everything went on, and where is that settlement report? In the absence, he says, therefore, of evidence to the contrary, it must be resumed that the grants was used in the established revenue connotation. It meant the lease of full rights over the land in question, subject always to the reservation by government of its inherent right to use the stream appropriate minerals. I therefore hold that the use of the word grant ipso facto voided the necessity of any condition in the body of the grant. I would observe that the embodiment of such conditions in later grants in Doon cannot legitimately be used as an argument to prove on the principle of exception probate legima that no such reservation was intended in the Wells grant. Let us suppose, however, that the mere use of the term grant was not sufficient in implying this reservation. It can nevertheless be shown that the reservation was one of the implied terms of the contract between the government and the grantee. For government in Wells settlements merely confirmed and took over, as it were, the transfer by the zamindars which had already taken place in favor of the grantee. So there is no proof. Now what does Arcadia means? An idealized country dweller, rustic in an idealized way. This way goes to say there is no proof of these grants. And these grants were revenue-free grants, or were they revenue grants? So Captain Brown is only looking for this. What? Three things: roads, canals, streams, or let's say if there was any mineral in the land. So he could only take this, and for this reason he could take my grant. Good morning. In continuation, now we will talk of the Wells Report, 1903. Now, what does he define the word grant or a grantee? The grant term was used for establishing revenue connotation, he says, or it meant the full rights to lease subject to reservation of government to streams and minerals. The enemy of one's enemy may be ipso facto a friend. He used to say that it is reasonably to state or believe something based on facts that are already known. You admit you fired the gun, and we now know that the shot killed the victim, so you are ipso facto responsible for his death. So this is what the word means technically in legal terminology. Well, further states cannot be used as argument to prove and the principle of exceptio probate legima, exception of the law, ignoratia les neme execust, ignorance is no defense, modus of operandi, method of operation how. So well is again stating that the formal Indian administration period, something like this could have taken place. So only the Raja had the complete sovereign rights in the soil. The zamindar, who must by himself be a grantee or had transferred the rights to another grantee, enjoyed reservations like this. So it was moreover clear the intentions of the government in giving these grants to make this reservation. Now this is in Exhibit 176. Where Mr. Well, I have stated my lease was registered at Do Raha, giving me exclusive possession of land. The public rights of access to stream, of course, this I am the sole proprietor. Again, we find the committee in their draft bylaws, passed at a meeting in 1840, securing the bylaws the right to the committee to make roads, streams, and same thing. So everything is concluding on to this fact. In conclusion, it may be added that the grantee would see in any case to be stopped from now denying the right of the government and through it of the municipality. So the government is trying to say that the original grantee or the sovereign was actually ipso facto now bounded by the terms of the grant, where the 3 or 4 rights go to the British government. So government intentions were very clear. That means that once a land becomes a grant, the government reserves its rights on these three things, and this is under the Land Acquisition Act also. So what are we actually trying to prove through this report? Now we come to the page 11. This deficiency is however supplied by Mr. Winter, pointing out by a roker of Wells dated 4th September 1842, which provided such auction sale proceeds like the annual rent reserved should go 2/3 to the Raja and 1/3 to the government. The draft letter acknowledges, and this is the same Akbari system. The draft letter shows the compensation of any land used by cantonment which had not been acquired by the 1830 agreement and stating that the matter had been referred to the government. So Raja was moreover not willing to auction or part with his lands. So he kept saying, you give me an annual rent. In 1894, when the government wished to use some of the unoccupied Tiri land for a municipal reserved forest, this implied the terms of the agreement which split knowledge. So grant could be only given after public auction. So what were the two things which are the sale price and the annual rent? Let's say if a grant had to move from one hand to the other. So again this exhibit 125 speaks of some 14,280 bighas of land in Jabar Khet as unoccupied land is fit for being included in government boundary. Therefore, it is taken within the boundary of Mussoorie. It will be under the management of the committee and will be disposed of to an applicant by auction and sale. Of the sale proceeds, government will receive 1/3 and 2/3 will go to the Raja. The villagers of neither territory will be stopped from grazing these lands. So everything kept going on. The Rajas also consent to the proposition that all lands within the boundaries of the settlement shall be considered as British possession, be of course forfeiting no right to rent and being allowed at the rate of an anna bigha in future. So there was an order which says in 1790 that the Britishers under the Board of Revenue Officers were looking for 1 bigha or 1 acre equivalent to an anna or 1 rupee today. So this was the basic feature, and this is how the lands were given or taken by the grantee in either a form of lease in perpetuity or they were public auctioned. So this kept going on. Now in 1842 between the Mahant and the government there was an agreement. So this agreement meant what? Only the Mahant being a British subject and the lands in question being at the time British territory, the agreement and any subsequent one between the Mahant and Indian government are cognizable by British courts and in all ways subjected to the laws of British India. The agreement is in fact was that the grantee or the mulfizdar of the government relinquishing to government certain of the lands granted revenue free to him on the condition that government continued to pay him certain sum of compensation as they became due. So the Britishers were taking up these lands which were driven out from the hands of the Raja to the local villager and wanted what? That okay fine, we take these lands, but on compensation on a regular basis, let's say we were asking for 1 anna per 1 bigha, you will be reimbursed to it. So now the term cantonment first appeared when the 1864 Cantonment Act came. When cantonment first defined the limits up to 1867 and later in 1867 after a notification number 106, dated 16 January 1867. Under mentioned officers are invested powers to try persons guilty of breach rules under section 17. Notification of 1867 further worries, and rules were framed under this act. But it is surprising that the Cantonment Act 1889 was never notified for Landour Cantonment. Now you have 1864 there, but 1880 or between were not there. So 1889 was. So Landour Cantonment only due to the existence of certain undetermined question of laws and facts affecting the limits to be assigned to the cantonment. The application of the act which question I shall endure forfeited. Dehradun was formally ceded by the Raja of Nepal in Article 5 of the treaty signed on March 4, 1860. So Raja of Garhwal was restored by a sanad. The boundaries of Garhwal were not defined. Certain gentlemen encroached upon lands like Karoli and other villages. The division of Raja's lands and the government land was the Panedal. If the water ran towards the north, it was the land of the Raja, and if southward, it was of the British government. South sides of the villages was of Chamsari, which was one and several villages owned by Mahant of Dera as a rent-free grant, which the British government acknowledged in 1815. This grant or Jagir is marked in a map, meaning hereby the government had no land at its disposal to devote to the cantonment and was compelled to acquire lands from the Raja or the Mahant. Now, these all points are very interesting if you read through. That nowhere the lands were to the British government for the making of the cantonment. So, the original occupation of Landour Kent is not very completely described in the correspondence. So, again now, to the Secretary to Government Northwest Province in the PWD Works Department, I have the honor to inform you that a reference to the record of the Office of Military Board shows that in December 1827, the buildings at Landour were just ordered to be commenced. It remains to state that grounds occupied by public bungalows at Landour and other perhaps now, which is as follows. Pragna, Jaunpura, Pakka Biga, 120, Mahant Saroop Das at Landour, Zamindari at Kakaroli. The proposal is eluded from the Hindi register and the government sanctions to the variations of 1829. The acquisition of lands in Landour was not possibly complete in the first phase in 1830, and later another attempt was made by Welsh settlements in 1842. This tract is there in Exhibit 1778/C. Now, if we go by another, presumably, what did Wells say? He clearly writes the sanction of government, which is not true as per the letter of 1830 from Major F. Young, who was the superintendent of Dehradun, to Colonel Tovey commanding the depot Landour, that the boundary pillars can be erected, but after the permission of military estate has to be added within the limits of the Landour. Now, where is it written? This clearly reads that permission has not been read. Exhibit 145 states that the letter 1830 was not there. Para 2, that portion of the ground rented from the Zamindar by military officers which was lying within the new boundary pillars of Landour has become a part of the military station. Now, the land was rented from the Raja but came under the military station, will in future be paid by government, and the bungalow thereon erected will be held by proprietors of on the same condition as similar property is held within the limits of the. Now, a man who is shifted into the bungalow is supposed to be holding that property or that bungalow in the same proprietary rightly conditioned in the military cantonment. So these two exhibits have clearly proven that lands within cantonments were held by the government on rent. So what is left in Landour now? Later the commander-in-chief moved and defined Major Young's report, for renting, which the proprietors had made private arrangements with the zamindars of Teri. Government settled all these matters arbitrarily by substituting itself as a lessee of the Raja in the rooms of two separate private leases. So at one stage from the Mahanti they picked up 700 bighas of land in Tiri and 300 in Charsmarri, and for a value of 70 rupees and 42 to be paid annually. So was this to be called ground rent for these two villages? The most important point is that looking at the map, letter 1832 shows that Lieutenant Tuckett estate is half and half out of cantonment limits. So the state Strawberry Hills in the map of Brown is shown as half of and other half is first estate, but the estate of Mackay has not been identified in any correspondence. It was probably that indicated as Woolsburn or Slateville or both in Brown's map. This shows that my estate was never within the limits of the cantonment and it was a private estate. So friends, these are some names of the estates which were considered at that time. This is Strawberry Hills, North and West End Cottage, Glengnow, Short Cottage, Garders in Orchard Cottage, plot near the hospital. So these all shows that how cadastral numbers were allotted and later given grant numbers by the superintendent of Dehradun. So here when I was making this report for Woolsburn, it clearly cited that in 1830 Woolsburn was given a survey number 74 and it was said it was a private proprietary grant. Friends, in continuation to the Wells report, now what is the distinction which this report talks in 1903? The controlled area or the cantonment area? So in 1903 we are being called a cantonment. Before proceeding, let's have some correspondence which happened between, so that we can easily make a distinction, if to avoid any confusion which permeates and distorts all discussions and actions. This distinction is that between the cantonment property and the cantonment area. Cantonment property is an area owned or in the case permanently rented by government for military quarters, etc. This meaning underlines the use of cantonment area in the documents which we shall consider and can be expressed by a cumbrous definition. It is defined local area occupied by or in the vicinity of military quarters within which government has bylaws, regulations, proprietary rights, persons and subjects. It is true that Sir Edmund in his speech dated 1902 on the Cantonment House Accommodation Act Bill before the Legislative Council maintained that such a distinction was abstract and not concrete, and that as a matter of fact government had never intentionally subjected to cantonment laws in any area which was not already a cantonment property. Read that the intentions with which we began to form cantonment was to include in them only or entirely at the disposal of the military authority cannot be denied, for the old regulations expressively forbade the inclusion of any land which were private property, and whole series of regulations and orders issued for the beginning of the last century onwards have consistently assumed and asserted the ownership of a state. But in disproof of this assertion, I would refer to Bengal Regulation 1810 and in particular section so and so. This regulation clearly proves that the limits under the control of the military authority in a cantonment were in those days not necessarily the limits of the government property, but might be outside and other than those limits. Now here is that catch. Now 1810 order speaks of, we had military boundary pillars, which we may call them cantonment boundary pillars, but referring to the House Accommodation Act speech after 100 years of 1765 approximately, it calls us that these past grants were in existence and cannot be said to be a part of this. It is evident that distinction between the limits of cantonments, property and the cantonment area was a real one in those days. As a matter of fact, it was the failure to clearly recognize this distinction, although it unconsciously existed in the minds of various parties, that was the cause of much playing to cross purpose in 1842 and onwards. The military authorities, when talking of the cantonment, were generally thinking of the area to be controlled, the government and civil authorities of the area to be owned. So this is where the whole story culminates. Board of Revenue was thereupon directed by government to take measures for acquiring all these lands except the Dhobighat, which had been declared by Wells to be a public property and was at once included in the cantonment under the Northwest Frontier Order of 1845. Well had meant that it should not be included in any grantee's private estate and no ground was therefore assessed on it. The Mahant, who must have been aware that his 2/3 of the share, which was prospectively the ground rent, was being diminished. Now this is very important. And what was the army looking for? Let's not ask for ground rent from the officers who occupied these built up bungalows. Why? Because they did not want any ground rent to be shown as rent of the property. So they were not claiming anything from the officer. Now the Mahant was getting disturbed that where is my 2/3 of the revenue which I had to get in the form of that rent. So this dispute existed. After a great inquiries, it was impossible for government to acquire rights in the said grants, owing to the high price. So the order very clearly says these lands were in Landour, Missouri, never acquired by the British. So now Landour cantonment boundary for pillars for the first time came up by Colonel Walker in 1866. They were altered in 1867 and apparently position by them was never been altered. While the Northwest Province Government number 375A of 9th May 1867, the boundary pillars were finally made. So, and it was notified. Both these pillars had a lot of discrepancy as the north side of 1830 boundary lines of cantonment properties and certain on the south side corners were to outside the cantonment. It appears that they never paid ground rent. All these properties stayed below the road on the north side and the upper circular road. This is very important now. You have Northwest Frontier being spoken again. And people in Landour or in these cantonments can weigh out what is on the south side of the river and what is of the stream and what is on the north side of the stream. So we have to see, let's say if there is a hill which is like this or if there is a hill which is like this and the water is flowing on the south side and the water is flowing on the north side. So this is how these boundaries were coming up. So friends, we need to understand what really is this report saying. So now the relation between the government and the municipality, which is government, or we can call it Nazul properties in Missouri. So Mahant and the Raja in some cases were considered to be clear-cut owners. So lands acquired or reserved for office, formerly the Belleville State, it is like the private grantees or perpetual leases of government. And so these grants were finally going into various hands. So where is this comparison which needs to be done? That has to be seen. So, every cantonment has these kind of records, because there was an example setting being done by the Britishers from 1900 after the making of the House Accommodation Act, that let's, for an example, make a record of right. So this is one record of right of 1903. Another was for Ambala. There is another record for Rangoon, that's Burma. In all these records of rights, admittedly the officer is admitting that these lands were never acquired by the British government. So were they taken on rent from the original grantees? Where are those documents? Or was these grants subjectively transferred to the British officers? There were two stages how they could be done. A grant, original grant, where the sovereign was the original grant. Either it moved to the hands of the villagers, subsequent grant, or the subsequent grant, or the Raja or the Mahant, let's say, these grants were auctioned to the British officer. And then roads were made and what the three terms of acquisition related to. And those days land acquisition was not there, because the Land Acquisition Act came first in 1850, then 1870, and then finally 1894. So at that time acquisition was for these three things, which is very rightly in 1894 also. If there is any mineral, water, and we have to make public roads and anything. So what is left? So you just need to understand and read all this. And I have been always saying, guys, we are old grants. We were never converted into new grants. That's the proof. And that the GLR says. We can hit it. And Landour, I would just speak a word. There is one bungalow owner, Mr. Sanjay Narang. He's got some 4-5 properties. That's how we came in touch. He's fighting some cases. His bungalow was demolished. I don't know what is the status of his case right now. But if he wins, everybody wins in Landour. But I can bet, if you read some books, which books finally went into his hand through my owner and my co-applicant for the Wolfsburn property, she shared my entire books with Sanjay Narang. I appreciate if they win all these cases, but small things will make a difference. So we have to be very cautious. We are walking on a sword edge. One mistake and we will be held via government lands. So please, you have to prove via you old grant. And where does this terminology old grant drives out to? Okay, bye-bye, good day.